Welcome to the 27th lecture of the lecture series on international arbitration practice. This lecture is a part of chapter 2 on invoking arbitration in international commercial arbitrations and international investment arbitrations. Lectures 19 to 22 dealt with invoking arbitration in international commercial arbitration, while lectures 23 to 25 dealt with invoking arbitration in international investment arbitration. In lecture 26, we dealt with parts 3 and 4 of the 12-part checklist for invoking ICISD arbitration. If you are here for the first time, do have a look at the previous two lectures. The links to the lectures are in the description below. In this lecture, we deal with the fifth part of the checklist dealing with claims. The 34th item in the checklist pertains to mentioning the substantive rights in the BIT that have been impaired by the acts of the host state. While dealing with the substantive BIT rights that have been impaired, it is usual to provide a summary of actions that constitute a violation of the BIT and state that the host state has engaged in unfair conduct. Extracts of the Notice of Arbitration in Chevron versus Ecuador can be seen for this. Para 68 says, Ecuador has engaged in a pattern of improper and fundamentally unfair conduct whereby Ecuador 1. breaches and effectively seeks to repudiate the 1995 settlement agreement, the 1995 municipal and provincial releases and the 1998 final release. 2. improperly exercises de facto jurisdiction over Chevron. 3. improperly assists and colludes with Lago Agrio plaintiffs in an effort to impose the state's obligations on claimants through the Lago Agrio litigation and seeks to improperly influence the courts through public statements. And 4. abuses the criminal justice system and pursues other inequitable measures to advance Ecuador's improper goals. The 35th item in the checklist is a discussion of the substantive rights available in the BIT. First, it quotes the obligation in the BIT and then goes on to state that the host state has breached the obligations in the BIT owing to the actions complained. Third, the Notice of Arbitration connects the ingredients of the obligation with the actions complained of or facts. This is illustrated by the Discovery LLC versus Slovakia Notice of Arbitration. Para 79 states, by preventing the claimant from being able to exercise its rights under the licenses which the respondent had granted, the respondent is in further breach of Article 2(c) of the BIT by failing to observe the obligations in those licenses. The claimant paid a substantial amount of license fee over the duration of its investment in consideration for the right to drill its exploratory wells at any time during the terms of the licenses. The breaches outlined above and the indirect expropriation of the claimant's investment in those licenses is a breach of Article 2(c). It then goes on to provide a non-exhaustive list of violations of the BIT by the host state by mentioning these failures vis-a-vis the BIT with specific obligations in the BIT. This is the 36th item in the checklist. Extracts of the Notice of Arbitration in Chevron versus Ecuador can be seen for this. You can pause this video and read para 69 of the Notice of Arbitration in detail. You would notice that this list is a non-exhaustive list, and against each provisions of the BIT, the obligation and the host state's violation of the obligation is mentioned. For example, the first bullet point mentions Ecuador's obligation to provide the claimant's investment fair and equitable treatment, full protection and security, and treatment no less than that required by international law, which is contained in Article 2(3)(a) of the relevant BIT. So, Ecuador complains that the conduct the Chevron complains that the Ecuador's conduct described in the Notice of Arbitration violates this obligation. Notice that the portion of the notice of arbitration states Ecuador violated the following treaty obligation among others. So this is a non-exhaustive list. There is a heading on claims for damages owing to violation of various provisions of the BIT. This is the 37th item in the checklist. The Chevron versus Ecuador, a notice of arbitration, does not contain this head in great detail, but recent notices have a separate head on claims. This makes the notice lengthier but self-contained. For example, the Discovery LLC versus Slovakia notice of arbitration has a specific heading on claims. We quote it here. The above stated breaches of the BIT have caused serious financial loss to the claimant. Such loss includes, without limitation, the loss of all acquisition, exploration and development costs which the claimant spent on the licenses. 2. The loss of fair market value of the claimant's ownership interest in the licenses, which it could have realized through the potential sale of all or part of that interest to a third party. 3. The loss of the net present value of the future cash flows which the claimant would have realized through its commercial development of the licenses but for the actions of Slovakia in breach of the BIT. Based upon its own internal assessment of its losses, the claimant estimates these to be in the region of USD 2.11 billion in relation to just shallow zones under its licenses. Significant value is also attributable to the deeper zones under the licenses. The claimant has commissioned an independent assessment of its losses and will provide a more detailed quantification and of these proceedings. While dealing with the claim for damages, you would notice that the claimant mentions the estimated amount of damages but reserves its right to provide a detailed quantification and substantiation during the arbitral proceedings. So that's all in this lecture. More on this in the next one. Bye bye and stay safe.